because once again, the Department of Justice has managed to pull off another maneuver that leaves gun owners shaking their heads and wondering what the real game is behind the curtain. Over the past couple of weeks, this isn't the first time we've had to peel back the layers on what the DOJ has been doing, and the deeper you look, the more it feels like a deliberate strategy. Just recently, on May 24th, the department conceded in a separate filing that suppressors are indeed arms under the Second Amendment. That was a massive admission, or at least it seemed that way at the time. But it's becoming clearer now that this acknowledgement wasn't meant to open the door to freedom, it was meant to strengthen their defense of the National Firearms Act, the very scheme that continues to hold suppressors hostage under federal law. Think about that for a second. For years, gun owners and advocates have argued that suppressors, yes, the same devices some people still insist on calling silencers, are simply firearm accessories that enhance safety and usability. They reduce recoil, they lower sound, and they protect hearing all without fundamentally changing the function of a firearm. For the DOJ to admit that these are arms constitutionally protected should have been the beginning of a new era. Instead, it feels more like a chess move, one that sets the stage for defending a registration and tax system that was never meant to exist once the original justification fell away. That brings us right into the case at the center of today's storm, United States v. Peterson. This isn't just another headline buried in the legal pages of some obscure law review. This is a real case with real consequences for the Second Amendment. At the heart of it is George Peterson, a Louisiana man who operated a small firearms business called PDW Solutions right out of his home. In 2022, after months of investigation, agents from the Bureau of Alcohol, Tobacco, Firearms, and Explosives raided his property. What did they find? Tucked away inside a safe was a homemade suppressor. It didn't have a serial number, it wasn't registered, and it had been built from a kit. That discovery was enough to bring the full weight of the federal government down on him. The indictment wasn't light reading. Peterson was charged under 3 separate sections of the National Firearms Act, 26 U.S.C. Section 5841, which deals with the registration of firearms, Section 5861D, which makes it illegal to possess an unregistered firearm under that act, in Section 5871, which outlines the penalties for violating these provisions. Together, these statutes form the backbone of the suppressor restrictions that have frustrated lawful owners for decades. It's a system that requires people to jump through hoops of paperwork, submit fingerprints and photographs, pay a $200 tax stamp, and then sit and wait sometimes for months just to exercise a right that is supposed to be protected. Peterson wasn't about to roll over. His defense team filed 2 key motions. The first was a direct Second Amendment challenge. Their argument was straightforward. The suppressor provisions of the NFA are unconstitutional. If suppressors are arms, as DOJ itself admitted earlier in 2025, then how can the government force citizens to register and tax them? The Second Amendment does not include an asterisk that allows for arbitrary fees, wait times, and bureaucratic red tape. The second motion was a Fourth Amendment challenge, and it struck at the very heart of the evidence against him. Peterson's team argued that the search warrant used in the ATF raid was defective. In their view, it lacked proper probable cause and should never have been executed. If the warrant was bad, then the evidence of the suppressor should have been thrown out. Without that piece of evidence, the government's case would have collapsed before it ever reached trial. But the district court didn't see it that way. Both motions were denied, leaving Peterson with little choice. He entered a conditional guilty plea, a legal move that allowed him to preserve his right to appeal the 2 major issues, whether the suppressor regulations of the NFA are constitutional under the Second Amendment, and whether the search warrant should have been suppressed under the Fourth. That set the stage for the case to make its way up to the Fifth Circuit Court of Appeals, where the battle would soon escalate into something far larger than one man's fight over a single homemade suppressor. When the case finally reached the Fifth Circuit, the anticipation was enormous, and for good reason. Everyone knew this was not just about Peterson anymore. His personal battle had become the vessel through which the government and the courts would attempt to redefine how suppressors fit under the Second Amendment. And the ruling that came down on February 6, 2025, has already sent shockwaves across the country. The appeals court upheld his conviction and rejected both of his challenges. On the Second Amendment question, the judges did something that almost felt like sleight of hand. They assumed without firmly deciding that suppressors are indeed arms under the Second Amendment. That might sound like progress at first glance, but what they did next completely undercut that assumption. The panel leaned on the idea that the National Firearms Act operates like a shall-issue licensing system. This concept comes from the Supreme Court's 2022 Bruin decision, where the court struck down discretionary may-issue carry permits, but left room for licensing systems that use objective standards. So the Fifth Circuit looked at the NFA's requirements, fingerprints, photographs, a background check, and the infamous $200 tax, and concluded that this was just another example of a shall-issue system. According to them, because the Act doesn't allow officials to arbitrarily deny applications, it should be presumptively constitutional. But that reasoning feels twisted. In practice, the NFA is nothing like the quick, streamlined checks that most Americans imagine when they hear shall issue. We are talking about months of waiting, an intrusive registration process, and a hefty tax just to own a piece of metal that makes shooting safer. Calling that the same as a simple carry permit is insulting to common sense. Worse still, the court pointed to the fact that Peterson never even applied for registration. Because he admitted he skipped the paperwork, they claimed he had no evidence that the system would have actually denied him. This is a clever dodge, but it ignores the reality that many Americans are effectively denied every single day because of the crushing delays and costs built into the NFA system. The government insists those wait times are now just a few days, but countless gun owners can testify that it often stretches into 8 months or more. The court brushed all that aside. On the Fourth Amendment issue, things didn't get any better. Peterson argued the search warrant lacked probable cause, which should have led to the evidence being thrown out. But the court applied what's called the good faith exception. In simple terms, that doctrine says that even if a warrant is weak, if agents acted as though they were following the law in good faith, the evidence can still be used. It's a safety net for law enforcement, but in this case, it effectively rewards sloppiness. The affidavit contained vague claims about unreported gun sales and alleged false statements, and that was apparently enough. The judges decided the agents reasonably relied on it, so the suppressor stayed in as evidence. In the end, the appeals court left Peterson convicted and left the NFA standing tall. For the first time, an appellate court had declared the suppressor provisions of the NFA presumptively constitutional by leaning on Bruin. That may sound like a technical detail, but in the world of constitutional law, that single phrase has enormous weight. Once one appellate court frames something that way, other courts are likely to follow. This isn't just a setback for one man. It's a potential precedent that could ripple through every other challenge waiting in the pipeline. For those who have been watching the government's moves, this outcome feels like exactly what the DOJ was setting up back in May when they conceded that suppressors are arms. They weren't giving anything away for free. They were laying the groundwork to argue that the NFA should be shielded from attack. And now with the Fifth Circuit on record, they have a judicial stamp of approval to wave around. The reaction to the Fifth Circuit's decision was swift and fierce. The Firearms Policy Coalition did not hold back labeling the ruling dangerously flawed and warning that it places the rights of every American at risk. Their statement cut straight to the point: suppressors are arms, period. They attach to firearms, they enhance safety, and they have a long history of lawful use. Even the government itself, just months earlier, had conceded as much. Yet the court refused to firmly recognize it. Instead, they danced around the issue and relied on a legal shortcut that stretches the meaning of shall issue to the breaking point. Other organizations followed suit. Gun Owners of America blasted the decision as yet another example of judicial gymnastics designed to protect government power at the expense of individual rights. The Second Amendment Foundation also signaled concern, pointing out that the court's approach undermines the clear test laid out in Bruin. That test requires judges to look to history and tradition, not invent new frameworks to uphold old restrictions. By leaning on the language of presumptively constitutional, the Fifth Circuit effectively insulated the NFA from the scrutiny it so desperately deserves. What makes this ruling so dangerous is not just the immediate impact on Peterson. It is the precedent it sets. Federal appellate courts shape the law for vast regions of the country, and their reasoning is often picked up by other circuits. If more courts adopt this line of thinking, suppressor restrictions could remain locked in place for years, shielded by a veneer of legitimacy that doesn't reflect reality. And once something is labeled presumptively constitutional, it becomes an uphill battle for challengers to prove otherwise. That's exactly why DOJ wanted this framing. It gives them a powerful weapon in courtrooms across America. The timing makes the situation even more concerning. Remember, beginning January 1, 2026, the NFA's tax provision was set to expire under the so-called One Big Beautiful Act. That meant the primary justification for the law, the idea that it was simply a tax scheme, would vanish. For decades, courts had tolerated the NFA by pointing to its role as a revenue measure. But with the tax gone, what's left to hold the rest of the scheme together? According to common sense, the answer should be nothing. Without a tax, the registry collapses. Yet DOJ appears to have maneuvered itself into a position where it can argue the registry still stands propped up by the Fifth Circuit's shiny new label of shall issue licensing. That is why groups like FPC are already preparing for the next battle. They know that Peterson wasn't the perfect plaintiff. He never applied, never paid the tax, and admitted he simply skipped the paperwork. The court used those facts against him, claiming he failed to demonstrate the system's real burdens. But the next case could be different. Imagine a law-abiding citizen who submits the application, pays the fee, and then waits 10 months with no answer. That is the kind of plaintiff who could force the courts to confront the reality of how oppressive this system really is. And organizations are openly encouraging such individuals to step forward. For ordinary gun owners, the implications are sobering. As it stands, anyone who builds or possesses a suppressor without registration is staring down serious federal prison time. The ATF has little reason to back off now that they can point to a federal appellate decision declaring their regime valid. And while the government claims wait times have improved, the lived experience of countless applicants tells a different story. Families are left waiting, hunters and sports shooters are forced to plan their seasons around bureaucratic delays, and all the while the government insists it is just a matter of processing. This is why vigilance matters. It is not enough to celebrate a single court victory here or there. The other side is constantly looking for ways to twist precedent-stretch definitions and carve out exceptions. They know that most people will not read the fine print of an opinion or study the footnotes of a legal brief. But that is where the real battles are fought and lost. The Peterson case proves it. One phrase, presumptively constitutional, is now being used to keep alive a law that should have crumbled the moment its tax was stripped away. So, where does that leave us? It leaves us with a call to action. Support the groups that fight in court because they are the ones standing between your rights and a government eager to erode them. Stay informed because knowledge is power in a system that thrives on confusion. And above all, remember that freedom is never guaranteed. It has to be defended every single day, case by case, word by word, ruling by ruling. If you found this breakdown helpful, make sure to hit the like button, share it with your friends, and subscribe so you don't miss the next update. Stay safe, stay vigilant, and most of all, stay free.